Lawyers of Reddit. What is the dumbest thing your client has done to client to ruin a case? Story 1. Client confessed online in trademark case. I was defending a client who was accused of trademark infringement. Thought he knew better than the intellectual property attorney assigned to his case, me, and so went on his company's website to defend himself by basically confessing to what he did and claiming it wasn't against the law, and the trademark owner was a woke baby who needed to either learn the law or get back in the kitchen and make her husband a sandwich. I wish I could say I was joking. I was one email away from negotiating a settlement that would have allowed the continued use of the complainant's mark with limited restrictions and a very nominal fee. Little to say, she saw his website, told us to go screw ourselves, and dragged it before a judge. My client lost. Big. His lack of self-control cost him thousands of dollars. Story 2. Client touched himself during arson trial. I have two stories that come to mind. One, a colleague of mine, was representing an arsonist many years ago that had allegedly set quite a large fire that burned some public land. Due to the dollar cost of the damage, it was a felony. During the state's case in chief, he began touching himself. Recess had to be called. Funnily enough, that helped him in punishment phase, since there was clearly a mental component there. But still, big oof, and I don't know if what had been shown up to that point would have gotten a guilty. Story 3. Client lied under oath about past driving under the influence. I am a criminal defense lawyer. Client arrested on driving under the influence. Client lived in a small town. He and his wife would drive to the one bar in town, drink, then walk to their houseboat after a night at the bar, 1/4 mile away. He and wife know everyone in the bar. Another patron they know gets blasted. Bar owner says she can't stay. Client and wife walk her to his car to stay there until a ride comes. Client gets her in the back seat of the sport utility vehicle. Client is drunk, drops keys on the way to the front seat, opens the now unlocked front door, turns on car lights to see. He walked around the front from the rear passenger. Cops are waiting to see if people leave the bar drunk, see lights, say he saw driving, immediately rolled up and arrested the client. Client has prior driving under the influence from 12-ish years before. Judge agreed that it wouldn't come in. The jury wouldn't hear it unless he, quote, opened the door. You can't win the case unless the dude testifies. I prep him, continue to prep him, keep prepping him, but tell him under no circumstances can he say he would never drive drunk, never do anything like that. Basically, anything about the past equals no. The direct is going well. Gave him a beautiful, easy, last question where he could explain the night, explain why he was upset he got arrested, because he wasn't driving and was doing everything right. I would never do something like that. Door open, judge lets district attorney in rebuttal bring in the old driving under the influence. The jury took about 25 minutes to convict, and that's about one of 100 stories. Life is never dull in the criminal defense world. Story 4. Client raised hand above shoulder during deposition. Legal videographer here. I videotaped a deposition for a man claiming work injuries so severe he could not raise his right hand above his shoulder, and his shoulder was in pain whenever he even tried to raise it above the shoulder. He sued his employer claiming it was a work injury. Then came his very first deposition. Does anybody know the first thing the court reporter asks of the person testifying? The reporter swears them in by saying, "Would you please raise your right hand and repeat after me?" Then administers the oath to tell the truth. The man who claimed not be able to raise his hand raised it without issue, contradicting his entire claim. Pakel. Story 5. Client lied under oath about prior medical history. I am a personal injury attorney. One time, I had a lady who needed back surgery after her wreck. All the doctors said she didn't need it before an 18-wheeler wrecked into her, but that she needed it after. It was a multi-level cervical discectomy, removing the soft tissues from between the vertebrae in the back of her neck, and it was going to leave her unable to work for the rest of her life due to all her restrictions. My client repeatedly swore that she had never, ever had a neck problem prior to the car wreck. The defense lawyer had found records from about 12 years prior, where she had been treating with a doctor due to neck pain for about 2 years, and sprung them on her at trial. My client's reaction was, "That's a lie, that's not me," even though the records had her name, birth date, and social security number. The jury came back and gave her $0 despite the fact that the wreck was the fault of an 18-wheeler driver. When I talked to the jury after the case, they said, "We just couldn't allow money in our verdict for someone who would lie under oath like that." If my client had simply told me that she had prior treatment on her neck so long before, it would not have been a big deal. All the doctors agreed that she needed the surgery because of the wreck. That case would have been worth more than $1 million in future medical care and future lost earnings. The summary is, my client lied under oath about something that wasn't that big of a deal, and it turned her case from seven-figure case into a $0 case. Moral: lying is bad. Okay. Story 6. Client threatened victim from jail. I had a client in jail awaiting trial on kidnapping charges. About a month before trial, this person sends a letter, through intermediaries, to the victim threatening both the victim as well as anyone that helps the victim. This was after the client had been instructed numerous times that, other than me, there was not to be communication in any way with anyone about the case. The prison listens in on all calls to inmates and reads all outgoing mail. Needless to say, the letters were intercepted and new charges of witness intimidation were filed. Prior to this, the client had a pretty decent case. Several months later, the client did the same thing over again. Story 7. Client showed up drunk to court. Not me, but I was at court early in the morning, and this one guy was there to see if the judge would end his probation term early. The dude had one problem though, he was hammered. He appeared fine, but when he walked up to the podium he was clearly slurring his words. They made him do a breathalyzer test on the spot, and he blew a 0.29 in front of the judge, and also had a half pint in his pocket. What's also crazy is that it was like 8 a.m., the judge had him locked up right then and there. Story 8. Client admitted to selling substances in court. A couple of decades ago, my friend was busted with cannabis. During his appearance in court, he told the judge that, quote, he wasn't going to smoke it all, most of it was for selling. He somehow thought that would get him off easier. He's an idiot, obviously. I swear you could see his lawyer wince as my friend said that. Story 9. Client denied knowing wine was alcohol during house arrest. I represented a girl in an aggravated assault case. I got her a really good deal where the lead charge was dropped, and she'd plead guilty to lesser charges and do 6 months on house arrest, with electronic monitoring, and the ankle monitor also had to have an alcohol sensor. 1 month into her sentence, I get a call from her landlord, saying she was arrested for a probation violation. Her ankle monitor detected her away from her house, and that she had alcohol in her system 2 separate times, and it alerted her probation officer. I talked to her at the jail, and asked her what happened. She acted like she had no idea why she was there. Her mom had just gotten out of the hospital from surgery, and needed someone to watch her, so she emailed her probation officer and asked if she could go to her mom's, and then just went. A few hours later, the probation officer responded and said she couldn't go, so she went home. Also, she had wine with dinner on 2 separate occasions, so it's not like she went out drinking or anything. None of it was any big deal. I was stunned by how nonchalant she was about it. I read her the riot act. There is one rule when you're on house arrest. Don't leave your house. You left your house. There is one rule when you're on an alcohol monitor. Don't drink alcohol. You drank alcohol twice. Her probation officer was recommending she be taken off house arrest and serve 6 months in jail. I told her the judge would probably accept that recommendation, and there wasn't much I could do about it because her violations were major. We go to court for her resentencing hearing, and I beg the judge to give her something less. I highlight all my clients' positive qualities as reasons to grant leniency, along with the fact that she admitted her violations and was very forthcoming with her probation officer about it. The probation officer then piped up. When I asked her about the alcohol violations, she said she didn't know wine was alcohol. The judge was considering giving her a minimal sentence until he heard that. It completely blew apart my argument. She was open and honest. Story 10. Client brought illegal weapon to court to prove innocence. I went to school with a guy who always carried a knuckle brass, illegal in Germany. Eventually, he got pulled over for not wearing a seatbelt and was caught with the knuckle brass sitting next to the radio. Police confiscated it, and he had to appear in court for possession of an illegal weapon. He then went on to completely deny everything he was accused of. He said the cops lied, he was being framed, etc. To prove that the knuckle brass didn't belong to him, he, in court, pulled out another one and put it on, claiming that this one is barely fitting him, and it was way bigger than the one they found in his car. Needless to say, he got convicted for both of them and had to pay a €1,200 fine plus 80 hours of community work. Fined. Story 11. Client falls asleep drunk in court, double sentence. Client charged with driving under the influence. Forced by police to give a urine sample on the side of a very busy interstate highway. Any sympathy the jury may have had for the defendant was lost, however, when he fell asleep during the playing of the video of the traffic stop. He had been out all night partying the night before trial. He was found guilty. Then he lied to the judge about what would be in his system during a substance test, and his sentence was doubled. Story 12. Client uses sheriff's info for fraud, loses deal. The second was one of mine, again, many years ago. I had gotten a guy a pretty great deal on a serious theft charge. Prior to it being entered, he ended up picked up by the sheriff's office for violating conditions of bond. How did he violate? The sheriff alleged that he used the banking information of the sheriff's office to pass fake checks. This meant that in the new charge, the sheriff's office was the victim. Needless to say, the deal vanished. Eichel. Story 13. Client blows substance test, loses custody case. Not a lawyer, but my ex totally messed up his custody case. In a nutshell, the mother took off with the kid and refused to return him in a state where that kind of action would get even supervised visitation taken from her. When she finally sent the child for visitation, the child had visible injuries caused by her boyfriend, and the child told his teacher at school, completely unprompted, that the boyfriend had hurt him. My ex's parents hired an attorney for him, and they got an ex parte order to keep the child. At the first hearing after the ex parte order, both the mother and father were ordered to take substance tests before the next hearing. My ex had a history of substance use, marijuana. His attorney told him he could get the next hearing pushed back by more than a month, so that he could be sure he would test clean, and my ex told him not to worry about it. Then did some cocaine and failed the substance test. He then didn't show for court and refused to contact his attorney for months, until the attorney had himself removed as the attorney on record. The child was actually at the mother's for visitation when the results came back, so she was able to get an ex parte order to keep him. The reality was he didn't actually want full responsibility for the child, but refused to admit that to his parents. So he deliberately blew the test, and then claimed that since he worked in construction, he must have been exposed to something that caused a failed substance test. I don't know if his parents really believed that, but I was with him for several years. Amon Bison. Story 14. Client rejects 0 extra days deal, faces life in prison. I had a client that was already serving a 25-year sentence for a series of burglaries. I was representing him for 3 more burglary charges in a different county, just across the county border. The state actually had evidence for 13 burglaries in my county, but picked the 3 best, with ironclad evidence. The prosecutor offered a 20-year concurrent, served at the same time, sentence, meaning if my client took the deal, he would serve 0 extra days in prison. I suspect the prosecutor had some sort of metric she had to meet. I met with my client dozens of times, explaining that, even if these 3 cases weren't ironclad, he would be risking consecutive sentences if even one of them got a conviction. My client was convinced his original conviction was going to be overturned. He turned down the deal and ran all 3 cases to trial. After the first conviction, with a consecutive sentence, the prosecutor withdrew the offer and forced us to trial on the second 2. My client was a young, 23 years old, black male, and is now sentenced to 25 plus 15 plus 15 plus 15, which equals 70 years in prison. He will die in prison because he would not listen to the expert appointed to represent him. If you feel unsafe with your thoughts, please seek professional help. Story 15. Injury claimant wins demolition derby before trial. I had a client with a back/neck/shoulder injury from an automobile crash win a demolition derby about a month before trial. The dumbass also sent his picture to the local newspaper bragging about his victory. Story 16. Public defender's clients make reckless moves. Man, I am a public defender. I got a new contender for this title every week. You want the story about the guy that gave his identification to the cop and then decided to run? Or maybe the guy that I warned not to call the victim from the jail who then called the victim and tried to manipulate them into retracting the story? I can go on all day. If they were smart and made good decisions, they wouldn't be my clients. Even stupid people deserve a fair day in court. Hell, especially stupid people. Story 17. Corporate client refuses testimony, jeopardizes debt case. I don't practice in debt collection anymore, but while I did briefly, I had a corporate client who refused to have anyone testify for any of their cases. For the most part, it's not an issue. However, we had a case where the opposing party was contesting the debt's existence, so at trial, I would need someone from the company to establish the debt/facts surrounding the debt. I tried reasoning that if they wouldn't testify, we would need to take the settlement offer that was about 1% of the total debt. They refused. I quit like a week later for partially unrelated reasons, but I was like, if you're not willing to establish the debt, what's your basis for the action at all? The last I checked, that case is still on the docket, so they just kept continuing it somehow. Story 18. Armed robber strips and confesses after being shot. I prosecuted a similar case. A defendant tried to rob a cash for gold store. He wore a mask and had a gun, but the owner pulled out his own gun and shot the defendant. The dude ran a few blocks but was found by the cops lying on the sidewalk in his underwear. He decided to strip while running. He said, quote, "I got shot. Robbery." He was recently released from prison for robbery, and the mask elevated it to a mandatory life sentence, if convicted. I offered him 20 years before picking a jury, and his attorneys tried their absolute best to convince him to take it, but he's clearly not the brightest. He had his deoxyribonucleic acid on the gun and mask he tossed, and the bullet hole in his shoulder from being shot. 26 years old male, at the time of conviction, and he will die in prison. Though I don't feel at all bad because Story 19. Client's aggressive behavior sinks settlement. Not necessarily in the courtroom, but I had a client accused of some rather aggressive behavior, is the nicest way to put it. During their deposition, this client frequently, and despite my many attempts to calm them, resorted to this aggressive behavior. The client did not get the settlement they wanted. Many subsequent tantrums were thrown. Ein point. Story 20. Client's constant whispers derail trial. The client wouldn't stop whispering stuff to me during his trial. Now, it's common for clients to do that from time to time, but this imbecile liked the sound of his own voice and would not shut up. It was usually him telling me to bring up stuff that had already been covered. He would do this while the judge was talking directly at me. It was extremely distracting, and there was nothing I could do about it. I tried reasoning with him. I tried berating him. I once threatened to stab him with my pen, And I tried getting my boss, who was a friend of his, to talk to him, but he just liked telling me what to do. For example, the judge mentioned the $3,500 for concrete. It went thusly. Me. Writes on pad $3,500 concrete. Him. Don't forget about the concrete. Me. Nods. Him. Are you going to talk about the concrete? Me. Yes. Him. Tell him about the concrete. Me. Taps the note I made about it. Him. You need to talk about the concrete. Me. Underlines it. Him. Bring up the concrete. Me. Underlines it aggressively. Him. Don't forget the concrete. Me. Be quiet. Him. But the concrete. Me. Shut up and let me do my job. This was all whispered in the middle of the trial. What an idiot. Whenever I tried talking about it during breaks, he'd giggle. Eventually I said, "You are the stupidest person I've ever met. I'm here to help you, and you're giggling while actively making it difficult for me." He just giggled more. In the end, the judge denied part of his claim, so the client got about $20,000 less than he should have. He was crying after he heard that. I told him that I thought the judge erred, and I could. Story 21. Client attempts to bribe witness via Facebook Messenger. Second day of trial, the other side's star witness is giving testimony. The next day, opposing counsel comes into court, and we all have a discussion about how my client attempted to bribe the witness to not come back over Facebook Messenger. Story 22. Client adds family to deed against advice, loses home in divorce. She put her son and daughter-in-law on her deed so she could avoid probate when she died. For reference, probate in our state is not that big a deal. There is no estate tax. She did this against my explicit recommendations. She assured me that it would never become an issue because her son and daughter-in-law would be married forever. You can guess what happened next. Less than 2 years later, she ended up selling her retirement home because half of it was considered marital property and her son's divorce. That can see an. Story 23. Client shows up drunk to pre-sentencing interview for driving under the influence. He showed up drunk to a pre-sentencing interview for his driving under the influence conviction. That can see an. Story 24. Client insists on felony plea over misdemeanor offer. Back when I was fairly new, I had a young man who insisted on taking a felony plea instead of the misdemeanor with active jail time, with work release. It took me ages to convince the prosecutor to offer. The young man had no prior criminal history, and no matter what I told him, he insisted he couldn't lose this new job he got. I told him, there's no way to expunge a felony in Virginia. He is stuck with this for life. This is the worst decision he can ever make. I went over the consequences of being a felon so many times. I had my boss lecture him too, but ultimately, it's his life to mess up. He called me 6 months later, having lost the job and finding it difficult to find a new one, wondering if there was anything he could do to fix it. I said no, and to his credit he acknowledged that I did tell him that. On the plus side, his story has stopped every subsequent client from making the same mistake. Story 25. Client starts committing same act they were suing over. I had to think on this for a while. They hired me because someone did something to them, and then mid-case I come to find out that they started doing the exact same thing to someone else. Can you help me with this? No. Is this going to affect my case? Take a wild guess. Story 26. Client rejects low offer, gets 30 years after trial. The client turned down a 12.1-month offer in 2014 after having spent 10 months in jail, currently serving 30 years with a release date of 2040 after losing at trial. Story 27. Client forges demand letter using lawyer's letterhead. All time might require too much thinking this morning, but let me tell you about this week. The craziest thing that happened to me in the past 5 days involves a client scanning my letterhead and creating a demand letter to a company written from my perspective with my contact info at the bottom of the letter, including a subpoena to them that was still within the notice period, in violation of the rule, and then copying me on the email, sending the letter and subpoena. When confronted, she claims I told her to. Yeah. I told her to send them a letter with her issue and give them permission to speak to me whilst providing my contact info as they requested when I called them. I didn't tell you to take my letterhead and send a bull demand, where I already told you the company did nothing wrong. It's your husband using their services inappropriately. Threatening litigation if they fail to comply. You can't make this stuff up. I think we determined she committed 1 felony and 2 misdemeanors. Unbelievably dumb. When we fired her, she threatened a bar complaint. Please do. We all need a laugh, and I'm definitely not worried we're still not refunding any fees for the work we did. It's a shame because she paid bills timely and I wanted to help her out, but if she's capable of that, she simply cannot be trusted anymore. Story 28. Client switches to pro se mid-trial in felony case. Deciding to go pro se in a major felony trial, while on parole for harm, when I was about 2 minutes into my opening argument. It was a defensible case too. Naturally, I was appointed as standby counsel, and I had to sit and watch as he slowly sealed his own fate. It was painful to watch. I still have no idea what he was thinking. I guess he made a split-second decision of, well, if I'm going back to prison for the rest. Story 29. Client lies about smoking and substances in med-mal case. A mother came in for a medical malpractice case for her new baby. She claimed she told her doctors what she wanted done. Ironically, it was the Captain Hindsight, perfect thing to do, and claimed they did not listen. The baby was born by emergency cesarean section for heart problems. It had to be resuscitated and has an intellectual disability as a result. Turns out the mom was lying. She was smoking a pack a day during the pregnancy, and had done pretty hard substances in the timeline of the pregnancy. She lied about that. But the medical records don't. Live. Story 30. Client pretends friend was driving under the influence stop. I've posted this before, but I had a driving under the influence client who insisted on going to trial. When he got pulled over, he jumped in the back seat and told the officer his friend was driving and ran off. He did all of this with the officer watching. He did not win at trial. Livin'. Story 31. Defendant wore crime outfit to court, prompting quick plea deal. I was on a jury where the defendant showed up in court day 1 wearing the same exact outfit as the quote, unknown suspect in the video of the crime. It took only a few seconds before the judge immediately called a stoppage. All the lawyers went into the back with the judge and they came out like 7 minutes later as announced the defendant had taken the plea deal. Wild. Ein. Story 32. Client left profane voicemails, leading to contempt hearing. The client was being sued and didn't like the opposing counsel or the judge, so he left the court a bunch of voicemails so profane that he was subject to a criminal contempt of court hearing. Livin'. Story 33. Defendant claimed no domestic violence on public property. With the utmost certainty in his voice, he yelled at the arresting officer that, "It's not domestic violence, I'm on public property." You could tell from his face he really thought he had the cop over a barrel on this one, but he. Story 34. Workers' comp claimant posted breakdance video, case dismissed. Not my client, but the petitioner attorney's client. The man claimed workers' compensation and threw the kitchen sink at us, meaning he basically listed just over half of his body parts on the claim petition, stating that he injured each one. He was full of crap, and my firm knew it. Anyways, we were going to trial, and the day before we ran one more social media search. This absolute jerk posted a video of him winning a breakdance competition that was only a few months after the alleged work incident. I never saw a quicker dismissal in my life. Story 35. Client released on bond, caught stealing batteries, bond revoked. Not an attorney, but one client of ours baffles me to this day. He had multiple cases, including aggravated battery and substance possession. At the insistence of the dude's family, we moved heaven and earth getting him a bond, so that he could get out of jail and live with said family until the case was over. The whole process took weeks. Less than a day after getting out, he was caught stealing $16 worth of batteries from Target. The bond was revoked. To be fair, the line between stupidity and compulsion is blurred with this one. Edit. For anyone who's curious, we immediately ordered a psych eval for him. He was found competent, but it also confirmed what he had: mental health issues. The aggravated battery charge ended up being dropped, and he took a plea for time served. Story 36. Widows Club photos with "I love MILFs" shirt hurt, wrongful death settlement. My wife's lawyer bans all clients from using social media after he lost a big case. A wrongful harm lawsuit where a man's wife was injured. Easy money. They were about to settle until the other side found his pictures online from a club a week after his wife died, getting a lap dance wearing a shirt that said, "I love MILFs." Apparently they didn't think he had much pain and suffering anymore. Vending hearing. Story 37. Defendant said no to remorse question, missed leniency. Not in the United States, but the judge asked if the defendant was remorseful. If you show regrets, you can have some leniency. No. The guy didn't understand the question, and when he doesn't, he just usually says no. Story 38. Client added years to sentence by attempting prison escape. The client added 9 years to a short sentence. He got like a year or two for being involved in a drag race that the other guy crashed and severely injured someone else. Then towards the end of his short prison term, he tried to escape, got 9 more years for prison escape. He became friends with John Lennon's killer in New York prison, which was interesting. Story 39. Worker admitted, ignoring out-of-order sign, lost injury claim. Not a lawyer. I heard this story from a guy the first used to work with. His brother-in-law got injured at work and was suing for a hefty sum. The case was pretty much open and shut. All the evidence was in the brother-in-law's favor. Until the brother-in-law started talking. They asked him to tell them about the day of the accident. The brother-in-law started out fine until he gets to the where he approached the piece of equipment that injured him. He tells everyone that there was a note on it, stating that it was out of order. The brother-in-law then says that he discarded the note and started up the piece of malfunctioning equipment as he had a job to get done. That easy win was discarded faster than that out-of-order sign. Story 40. Embezzler blames charity for easy access to funds, worsens sentence. Not a lawyer, but somewhat pertinent. Last year I had some legal trouble that involved court. The case being seen before mine was an embezzlement case, where a man who volunteered for a nonprofit kids charity was using company funds to support his family after he lost his job. He stole something like $80,000 from them over the course of 2 years. His lawyer had arranged a plea deal for him. No jail, 2 years probation, and pay back every cent. The whole thing was arranged. The judge agreed, but before sentencing asked the guy if he had anything to say. The guy's response: "Yes, Your Honor. I regret what I did. I ruined a company and hurt kids. But, they let me have access to the money. That was a really stupid move on their part. Someone should look into how they run their business if they let someone like me just take a bunch of money." His lawyer, the prosecutor, even the judge tried to shut him up, but he kept going like that for at least 5 minutes, blaming the organization, blaming the kids involved, even blaming his parents and the military, and then admitting part of what he used the money for was substances, which had never come up before apparently. The judge kept to the plea in that he was only guilty of 1 count of embezzlement and 1 of theft, but slapped him with a max sentence and fine and restitution. All he had to do was keep his mouth shut and agree to pay it back. Story 41. Client's social media post derails workers' comp claim. Not an attorney. I worked in a firm. It was a workers' compensation claim. A guy falls down at work and claims he injured many different body parts, shoulder, knees, back. We tell him to stay off social media. No problem, he doesn't use social media. At trial, he tells the judge he used to be a spin class instructor, but since the accident, he cannot teach classes anymore. Well, it turns out he continued to teach these classes after his injury. This was proved by the hours of surveillance the insurance company did, showing him teaching and vigorously riding in spin class. How did the insurance company know he was still an active instructor? The guy posted his full teaching schedule on his Facebook page. His potentially very lucrative claim was quickly changed to a fraud claim against him. Story 42. Client's panic attack silences him in court, loses case. Briefly, he had to testify that doing X thing would not cost him a lot of money. The judge asked him how much money would it cost for him, and he said an amount which was not too much for him, because he was rich. But it was a lot, compared to what everybody in the courtroom was making. The other case. The day before the court, I tell him exactly what he is going to answer to certain questions. I specifically tell him to answer X when asked. The time comes. The judge asks. He completely loses it. He gets a panic attack. He can't even speak a single word. He just looks at the judge with the 1,000-yard stare. Disaster. Story 43. Client's magnet therapy. Revelation sinks injury claim. She was doing magnet therapy with a therapist 5 hours away by phone. The therapist had the magnets. My client would hold the phone up to various parts of her body that needed the magnetic energy to help it heal, for $2,000 a month. She never told me about this in the dozens of hours we prepared by talking everything through. I learned during the other side's cross of her. I've never been tempted to head desk in court before. Story 44. Client's fist clenching undermines arthritis defense. A client was accused of punching another man and knocking a tooth out. He said numerous times on the stand that he had arthritis and was not capable of closing his fist to form the punch as described by the victim. Partway through his cross-examination, the magistrate stopped him to state on the record that he had watched my client clench his fist numerous times since he made that statement. He was found guilty. Story 45. Client admits crime on recorded jail call. He admitted to the crime he was accused of over the jail phone, which, for those of you who don't know, is recorded. He had been maintaining his innocence up until that point, and there was a good chance he'd be acquitted since the prosecutor didn't have much of a case until he ran his mouth. We were ready to go to trial and everything. What makes it even dumber is that he'd been to jail numerous times beforehand and knew his calls were recorded. The jail phone even tells you the calls are recorded before you make the call. I had to plead him out to 10 years since he was facing 25 life. End. Story 46. Client wears wife beater to domestic violence court. Not mine, but a former co-worker's case. The client was accused of domestic violence against his wife and had to make an appearance in front of the judge. The client shows up to court literally wearing a wife beater. Story 47. Fake injury exposed on camera. A client came to tell us a car backed into his motor scooter and fell on him and broke his leg. He already had 4 or 5 cases with us. We found footage of the incident soon after, which revealed he ran around the moped, laid it down on the ground, ran back around it and laid underneath it, and started wailing. Story 48. Defendant admits guilt during lawyer's defense. A friend of mine is a criminal lawyer. In one case, he was going on a 2-hour-long statement how his client could not have committed the offense. Almost at the end of his statement, his client stood up, tired of the long monologue, and admitted that he did it and to get it over with. Story 49. Intoxicated spouse disrupts divorce hearing. I was a family law legal assistant. My boss was co-counsel on a divorce case involving a wealthy family. Our client was a big law partner. There was a protective order in place, and the opposing party had violated it by coming to the family home intoxicated and interacting with the children. We were in court to enforce the protective order, and at 8:30 in the morning, the opposing party was clearly intoxicated. She had shown up pro se because her attorney had withdrawn a few days prior. She tried to engage me in conversation, very loudly, throughout docket call. When docket call was over, and our motion was to be heard, my boss stated his appearance for the record. The opposing party started to state her appearance, then made a weird digression, where she said she wanted to flick her married name out of the appearance and made a thumping motion with her fingers. The judge interrupted her and said, "Are you intoxicated? It is 9 a.m. I really can't believe you have so little respect for this court. Bailiff, please take her into custody, and if she won't consent to a breathalyzer, I'll draft an order for a blood draw." She flipped smooth the heck out. She ran at the bench, tried to climb it. The judge said, "I'm sentencing you to 7 days for contempt." She kept going. He said, "I'm now sentencing you to 14 days. And she kept flailing around. At this point, he left the bench for his chambers, but I think more as an effort to keep from losing his temper than out of fear or anything. The deputy got her down on the floor and cuffed her. The judge came back and ended up sentencing her to 30 days. She didn't serve but maybe 3 or 4 days. She retained another attorney and was released to inpatient treatment. The attorney she hired was a notorious drunk and an extremely frustrating attorney to handle cases against because of his poor client control. That was 15 years ago, and I remember thinking, man, I don't think I want to go to law school. I run an animal shelter now. The legal profession sucks. Edit. Interestingly, our client was also fond of sabotaging his own case by standing up during hearings and addressing the judge. Attorneys are the worst darn clients. Story 50. Admits crime on video, posts guns on social media. I had a client who admitted to a crime on video and posted pictures with guns on social media, leaving a clear digital trail. Additionally, he left his identification at the crime scene, making it impossible to deny involvement. These actions provided prosecutors with direct evidence, likely leading to a conviction, and eliminating any chance of a successful defense due to his own incriminating behavior.